The problem with guardians ad litem, part 2 of 3. As any attorney can do with any client, a PGAL clearly has the right to argue on a child client's behalf, and the Utah Code makes clear that a PGAL can express a child client's intentions and desires. See Utah Code section 78A-2-705 subsection 13D. When a PGAL tells a court, quote, "I've spoken to my client and based upon those discussions, I can tell you that it is his or her intentions and desires as follows," is hearsay, or at the very least, inferential hearsay. It can't be anything else. Such a hearsay declarant is at least subject to cross-examination. See Utah Rules of Evidence 806. There is a pervasive belief among Utah family law attorneys and judicial officers that a child represented by a PGAL cannot even be cross-examined. There is no legal authority for this. Indeed, all legal authority is to the contrary. Children testify in Utah juvenile court proceedings, and when they do, they often do under various circumstances, regarding child custody and parent time being among them. These are substantively indistinguishable from testifying in a district court child custody and parent time case regarding divorce or child custody on its own. When district courts try to make a distinction between testifying in juvenile court and barring testimony in district court, they fail. They must. It is a distinction without difference. I really do not understand why everyone frames, or tries to frame, asking questions of children who are the subject of a child custody and/or parent time dispute as inherently harmful to the children. One can ask certain questions that harm or elicit answers that harm, but all forms of questioning are not innately harmful to children. Moreover, there is a level of harm that is, frankly, justified when the value of the testimonial evidence elicited is greater than the harm caused or that may be caused. This is why we jail witnesses who are afraid to testify against the mob, yet we mitigate that by putting them in witness protection. Where there's a will, there's a way. Unless they are very young, children are not so ignorant as to have no idea what is happening in their own child custody dispute case. They know that if there is a dispute over custody, that one parent will likely be unhappy. The children aren't surprised when one parent or both parents try to lobby to support their candidacy for best parent or custodial parent. They aren't surprised, the children aren't, if a court wants to know what the children have experienced, how the children feel, and what the children want on the subject of the child custody and parent time awards. That's obvious. There are clearly ways to obtain valuable evidence that children, and only children, are uniquely able to provide on these subjects. They do that in the form of their own testimony about their experiences, observations, feelings, opinions, preferences, and desires on the subject, and they can do so without it harming or unduly harming them.